LLC.
Okay, let's proceed.
Thank you, Your Honor. First, if we may, plaintiff has raised several points of objection in this motion. I think the first one, if we can address the timely issue.
Okay.
Plaintiff's counsel has incorrectly cited or incorrectly interpreted the responsible third party statute, which is 33.004. Section J is where we are. In that section, if no later than 60 days after the filing of the original answer, defendant alleges in an answer filed with the court, with the unknown person. And that is what we have done in this situation. Our original answer was filed on June 24th of this year, and our first amended answer was filed on August 18th of this year, within the 60-day period in which to designate.
Okay, go ahead.
So I would address the court, or let the court know that I do believe that this motion is filed timely. Our answer was filed timely. The motion itself does not have to be filed until 60 days before trial. Trial is not set in this matter. Discovery has just begun. We are in the very early stages of this case. I believe this motion is filed timely according to our amended answer.
So Jay says, notwithstanding any other provision of this section, if not later than 60 days after the filing of the defendant's original answer, the defendant alleges in an answer filed with the court that an unknown person committed a criminal act that was a cause of the loss or injury that's subject to the lawsuit, the court shall grant a motion for leave to designate the unknown person as a responsible third party. So where do you get that this is 60 days before trial?
That is in the section A, that a defendant can file a motion for leave on or before the 60th day before trial. Just wanted to bring that up, as we are not at that point right now.
But is this a designation under J or under A?
Yes, Your Honor. Sorry, under J. I apologize.
Okay. Response to the timeliness issue?
Your Honor, I think A, the 60 days before trial applies when there's a known party. For unknown parties, it's governed by J. And I do agree that the language there says defendants have to state in an answer within 60 days. So by the wording of the statute, I actually do think that it is timely.
Okay. You think it is timely?
Yes, Your Honor.
Okay, let's go to the next issue then.
Thank you, Your Honor. The next issue that plaintiffs raise is the pleading requirements of this matter. As the court can read, the pleading requirements begin with that the defendant has pleaded facts sufficient for the court to determine that there's a reasonable probability that the act of an unknown person was criminal. In this matter, in our amended answer, we did assert that the unknown third party was backing up at the time of the accident. We received this information from a police report in which the plaintiff said that was happening, that a car was backing up at the time of the incident. We also just received and have disclosed a recording that also you can hear the plaintiff saying that someone was backing up into him at the time of the accident. In terms of that being a criminal matter, that would fall under reckless driving. This unknown driver was backing up on a highway in the left lane. He or she had to choose to make that decision, and therefore was driving in a willful and wanton manner, since that person had no regard for the safety of others. One expects to be moving forward.
Is there any case law on this issue about, because that would really mean any car wreck case, you could do this?
Your Honor, I did not find any exact case law on point. I think that the way that this case differentiates from other car accidents is that if a person, you're expected to move forward on a highway. And if this person is choosing of their own volition to back up, that is willful and wanton, causing reckless driving, which is a Class B misdemeanor.
Response?
Yes, Your Honor. Your Honor, in our motion, we cited to a case 5N Cal v. Hardy. That was a case where the defendant moved to designate as a responsible third party the unknown driver of a vehicle that was disabled on a highway. So not backing up on a highway, but disabled on a highway, similar offense. And in that case, the court held that the pleading requirements were not met, that the unknown person had committed a crime. I think the legislative history in this area also makes it clear that misdemeanors were not the intent of the unknown responsible third party statute, that they were looking for higher standards, and that merely saying misdemeanor crimes or negligence or even gross negligence is not sufficient to overcome those pleading requirements. Additionally, Your Honor, just to give us some reference on the facts that we're dealing with here, this is a crash where my client was rear-ended when they were slowing on the highway for traffic ahead of them. It happened in this circumstance that traffic ahead of them was moving backwards, but there's no allegation that my client struck the vehicle ahead of them or that things would have been any different if they were slowing for traffic under normal circumstances. So not only is there an issue of them failing to meet the pleading requirements, there's also an issue of proximate cause. How did the allegations they made in this case is that the unknown driver committed a crime by leaving the scene? How did leaving the scene cause the defendant in this case to rear end my client? There's no connection there.
All right, I'm going to deny the motion for leave. Have you submitted an order, Mr. Zaidi?
We will. Thank you, Your Honor.
Your Honor, just a moment. May I ask for leave to replead in this matter?
Mr. Zaidi, are you opposed to that? I don't know that you need leave, but are you past the filing deadline or pleading deadline?
Based on the provision, Section J, and if we're not going to go with Section A, 60 days before trial, then there is no deadline that is stated in the statute.
Your Honor, unless there's some new facts or something substantial that turns up, I'm not sure how repleading this is going to fix the proximate cause issue.
I just don't. I think you're kind of trying to put a round peg into a square hole here. But if you want to file something else, obviously I'll consider it.
Okay.
So, Mr. Zaidi, when you file the order here, make sure that you indicate that it was this hearing was held on October 11th. Please email my court coordinator as well as e-file the proposed order. Okay.
All right, will do. Thank you, Your Honor.
Thank you, guys. You guys have a good day.
You do the same.
All right, we have both sides here on Diana West versus the estate of Deanna Sue Johnson.
Yes, Your Honor.
Yes, Your Honor.
All right. Tony, let's go on the record on DC 20-17917, West v. the estate of Deanna Sue Johnson. Counsel, make your appearances.
I'm Lauren Cadillac. I represent the plaintiff.
I'm David Griggs, the attorney ad litem, representing the defendant, estate of Deanna Sue Johnson.
I want to commend you, Ms. Cadillac, on your Zoom decorations there. Your name, that's really good. I like that.
Thank you, Your Honor.
Go ahead and proceed, Ms. Cadillac.
Okay, Your Honor. This afternoon, we are going over a motion for summary judgment, which we submitted. Brief overview of the facts. Ms. West, the plaintiff, was married to Mr. Charles Joseph Duncan. Mr. Duncan was the nephew of Deanna Sue Johnson. Miss Johnson passed away in 1983, and Mr. Duncan and his wife, Miss West, my client, moved into the property, and they maintained the property and have paid the taxes ever since. Mr. Duncan has since passed away, and so Miss West has continued to do so after he passed. She's done this openly, notoriously, and peaceably for the last 38 years. So attached to our summary judgment, Your Honor, we have evidence that Ms. West has been paying those taxes. Unfortunately, the records from the 80s were unavailable. However, we have attached evidence showing her payment from the 90s, which is over 20 years. This is a suit to quiet title. We did have leave of court to do notice by publication, and Mr. Griggs was assigned as an ad litem. Is my understanding he has filed a report with the court, and if the court so wishes, I'm sure he'll be happy to go over it. Mr. Griggs and I did speak before this hearing, and he is not in dispute to our motion before the court. And in fact, we agreed as to what his ad litem fees would be. And I know he submitted an order, and so my client has no objection to those whatsoever. So we are looking for the court to grant the motion for summary judgment under the theory of quiet title and adverse possession, as our client has certainly met the 20-year statute under Texas law. And there are no issues as to facts or law before the court.
Mr. Griggs?
Yes, Your Honor. I did conduct an investigation in this matter. My normal computer searches to look for errors, as well as in this case, I had two family friends that I was able to interview that I was provided. All of the indications that I have are that the facts as presented in the plaintiff's original petition were accurate. The relationship between the parties and the fact that there are no heirs. And I also looked, Your Honor, to verify the taxes paid, and that looks to be accurate as well. So it appears to me that there has been continuous payment of those taxes over the years, and I have not been able to find any additional heirs other than the plaintiff, Diana West.
Okay, the court will grant summary judgment as requested. Did you already submit an order?
I did, and I emailed it to Ms. Rhonda as well, Your Honor.
All right, let me just see if I can find it. And does the order contain Mr. Griggs's fees?
He submitted a separate order, which has his fees, and we have no objections to that order.
All right, give me 1 second to make sure I have them.
Those were filed today, Your Honor.
Oh, they were filed
Probably
today.
were uploaded this afternoon.
Okay, and did you email Rhonda the order too?
No, but I can certainly do that right now. The proposed fee order for my fees, is that what
Well,
you said?
let me just see if the orders are online and I can sign them right now.
All right. Terry, I think, just uploaded my report, and the other one appears to have been accepted earlier this afternoon.
Oh, they're both here. Yeah, I can sign them both right now. Let me just take a look at them, make sure they're good. Okay. And you've looked at the order that she submitted. You don't have the opposition to it, Mr. Griggs?
I do not. Thank you.
Okay, and then let me take a look at the order for fees. And according to this, it's $1,200. Is that correct?
That's correct, Your Honor.
Okay, I've just signed both orders. They should be uploaded momentarily. You should be able to get them, I would assume, by tomorrow. Okay.
All right.
Thank you, Your
Thank you.
Honor.
Thank you, Your Honor.
Thank you. You guys have a great day. Okay. And thank you for your service, Mr. Griggs.
All right. Thank you, Your Honor, and good work with you, Lauren.
You as well. Thank you, Your Honor.
Okay. Okay. All right, so we have an emergency TRO that just got filed, guys. So let me